It's California Edition. My name is Brad Pomerance. We are joined by Bill Monning. He is a member of the California State Senate. He is now the Senate Majority Leader and on the Health Committee in the Senate. I'd like to speak with you about something that's hard to discuss, but it's important to discuss, and that deals with end of life. There has been a lot of news surrounding end of life. We know Canada recently legalized end of life options. The Brittany Maynard case got a lot of press. Talk to me about what's happening in California on this very question.
Well, I've introduced Senate Bill 128 with Senator Lois Wolk, which would make law in California allowing an end-of-life option for a very limited universe of patients. A person with a terminal illness with less than 6 months to live, who is also mentally competent, and who gets an opinion from two independent doctors not working for the same employer that the disease is terminal, and then a 15-day waiting period to successfully get a prescription, which basically is a lethal prescription. It allows that patient to determine under a death sentence of a terminal illness that within that limited time to live that they will have an option, if the pain is too great, the suffering is too great, to have a compassionate transition with family members present.
We know that Oregon was a forerunner on this very issue, and when I hear what you describe, it sounds very similar to what I understand Oregon adopted. Is it modeled exactly after Oregon?
It's very similar. It's certainly built on the Oregon experience and the law. We've made, I think, some improvements for California, including more specific immunities for doctors and pharmacists, as well as a translation requirement for a non-English speaking patient. If they're having this conversation with a doctor in a non-English language, there would have to be evidence that it was translated to the target language. So we think we've built upon what has been very successful in Oregon, 17 years of experience in Oregon, no lawsuits, no legal complaints, no evidence of coercion. And our bill also would prohibit any health insurance plan or a life insurance plan from being canceled or nullified or modified if you use the prescription or if you don't use the prescription. In other words, it can't affect insurance one way or the other. If a patient with a terminal illness chose to exercise this option, the cause of death would be the underlying terminal illness.
It would not be suicide, for
Correct.
example. What is the cost of the medication? Is it prohibitive? Or?
It's a couple $100s. It's
Okay.
not insignificant, but it's definitely attainable by most, and some health plans would cover that cost.
Let's dig deeper on this. In Oregon, do they mandate that insurance companies provide end-of-life medication?
You know, it's a good question, and I don't know the answer to whether it's required. But I think if you look at how our bill is drafted, not to cover it could be considered coercion or non-compliance with the law. But that's something we'll have to look at as it goes through the legislative process.
Yeah,
You're the first one to ask that.
I know,
it's
it
a
just
good question.
kind of hit me that do they need to be obligated to provide this coverage? And then it brings up the whole question of religious exemptions.
Right.
Wow, I'm sorry that I brought this up on your
No,
behalf.
it's a fair question. They certainly couldn't deny coverage based on your decision to exercise the option. It is absolutely voluntarily, first and foremost, for the patient. We see this as a fundamental patient right, respecting and protecting the autonomy of a patient to make a very personal decision at the end of life. That said, this bill does not mandate a physician to participate, or if he or she does not want to, would not mandate a religious hospital facility, for example, to have to participate. This would honor anybody's religious belief or desire not to participate.
But when you think about coercion, and let's just focus on the insurance company, end of life is incredibly expensive. The care can be, I mean, literally people go bankrupt because of costs at end of life. And so query, I mean, if the insurance company has the ability to provide this medication for $200.
But they can't provide it as this is all we're going to offer you. We're not going to offer you coverage for this more expensive end of life. That would be a felony in my legislation. It's a felony act if there is coercion by an insurance carrier. So in other words, from their cost-efficient basis, they couldn't persuade, coerce a patient. We think you should pursue this option. And we protect it that the patient is the person in control of exercising this option. But there have to be two witnesses, and neither witnesses can't, of course, be associated with an insurance provider or somebody who has a vested interest.
Do the witnesses, are they allowed to be related?
One can be a family member. They can't both be family members. One could have an interest in an estate, presumably the family member, but not both. So that the witnesses, you have a separation in terms of who would be considered a legal witness. And again, as I mentioned, there's the translation requirement.
Right.
If this were the will of a patient who was not native English speaker.
In the final analysis, when we look at what happened in Oregon and otherwise, we do know opposition is strongest from certain faith-based communities. The Catholic Church has come out against, I don't think your bill specifically, I'm not aware if they have,
haven't.
But there's no doubt that faith-based communities have had difficulty dealing with this question.
That's right.
And so, you know, you're someone that I know that wants to be collaborative.
Right.
And so where do you go with the faith-based communities?
Well,
on
we've
this very
reached out
question?
to faith-based communities, particularly the Catholic Church, had very, I would say, respectful and good conversations with the Archbishop from Los Angeles, a bishop from my district, and a respectful recognition of church doctrine. My bill doesn't seek to change anybody's religion or anybody's faith-based beliefs, and that would include the Catholic Church.
What about the medical associations? In the final analysis, as I say, you know, the purpose, what's the oath, the Hippocratic oath, do no harm.
Right.
Arguably, ending life is doing harm, arguably.
Or arguably somebody who's suffering hugely, unnecessarily, is that not doing harm? But you framed the question, Brad, and we have engaged with the California Medical Association. They have not taken a formal position on this legislation. Their standing policy opposes death with dignity. But there is a changed demographic. We know nationally a majority of physicians polled are supportive. We know that there are many members within the CMA who are supportive. And so part of their governance process, which is a very robust governance process, they have a House of Delegates, they have a Council on Legislation, they have an ethics committee. And so we're engaging in their process, and they've been very open to inviting Senator Wolk and me to engage with them.
I want to ask about members of the legislature that may be on the right of the political spectrum. A lot of those that are on the right, they will define themselves as conservatives, but yet they may have a libertarian bent.
That's correct.
And a libertarian bent could be in support of something like an end-of-life option.
Right.
Whereas a conservative bent may have some religious implications
Right.
sway.
Yeah.
So what are your friends that are saying to you that are on the right of the political spectrum?
Well, you've dialed right into, we think this kind of defies partisanship. We found among our Democratic colleagues many supporters, and then some with some reservations.
Sure.
And among
immigrant Catholics, for example, may have some challenges. Those supporting immigrant
but not
communities.
exclusively.
Of course.
And then among some of our Republican colleagues who were just really beginning the conversation with very, I would say, very open-minded and encouraging. So it's early on. We've just introduced the legislation.
But to great fanfare. I mean, I was actually, I have not seen a bill receive as much play and press in a long time as SB 128.
Yes.
How'd that happen, sir?
Well, I think a certain convergence of historical forces. The Brittany Maynard story had been headline news, and it had crossed the divide from just media to
it was on People Magazine.
People Magazine, for example.
Okay, I want to thank you for joining us. Will you come back and continue the conversation?
I look forward to it.
Appreciate it. His name is Bill Monning. He is a member of the California State Senate, Senate Majority Leader. In fact, I'm Brad Pomerance. It's California Edition.